Ladies and gentlemen, distinguished colleagues, students of law and democracy, let me take you on a journey into one of Zambia's most important constitutional landmarks, the case of Christine Mulundika and 7 others versus the people. Imagine this, it's the mid-1990s. Zambia is still finding its feet in the exciting, sometimes turbulent transition from one-party rule to multi-party democracy. Citizens are eager to speak out, gather, and organize, but an old colonial law from 1953 stands in their way. That law is the Public Order Act, Chapter 104. The spark of the case. Christine Mulundika and 7 others decided to hold a public assembly or procession. They didn't apply for a permit. They were arrested and charged. Rather than simply pleading guilty or not guilty on the facts, they took a bold step. They challenged the very law under which they were prosecuted. They argued that the requirement to get government permission before people could peacefully assemble was unconstitutional. The case moved from the subordinate court to the High Court, which upheld the law, and finally landed before the Supreme Court of Zambia in 1996. What was at stake wasn't just one gathering, it was the fundamental right of ordinary citizens to express themselves and come together without asking for official approval first. The heart of the dispute. The key provision in question was Section 5(4) of the Public Order Act. It said that anyone wanting to hold a public meeting or procession had to apply to a regulating officer, usually a senior police officer or district official. The officer would grant a permit only if he or she was personally satisfied that the event was unlikely to cause a breach of the peace. No permit, criminal offense under Section 7. There was also a side issue. Certain government officials were exempt from this requirement. The appellants called that discriminatory. The appellants grounded their challenge firmly in the Zambian Constitution, specifically Articles 20 and 21, which protect freedom of expression and freedom of assembly and association. Yes, these rights are not absolute, but any restrictions must be reasonably justifiable in a democratic society. The arguments in court. The appellant's side, Mulundika and others. This law gives one person, the regulating officer, almost godlike power. They can say yes or no based on their own subjective feelings, with no clear guidelines, no obligation to explain their decision, and virtually no meaningful way to appeal. That's not regulation. That's a prior restraint that can kill a gathering before it even begins. It's a colonial relic that has no place in a modern democracy. The state side. Public order matters. Without permits, there could be chaos. The police need to know what's happening so they can manage crowds, traffic, and potential risks. The Supreme Court's landmark ruling. In a powerful majority judgment delivered by Chief Justice Ngulube, with Justices Chirwa and Muzyamba, the Supreme Court agreed with the appellants. Here's why their reasoning still resonates today. The permit system created an unacceptable risk of arbitrary abuse. A single officer could deny fundamental rights for good reasons, bad reasons, or no reason at all. True democracy thrives on pluralism, tolerance, and the free exchange of ideas, even uncomfortable ones. Requiring prior permission turns a right into a privilege. The court looked around the Commonwealth and beyond, to cases from Ghana, Zimbabwe, the United States, Shuttlesworth versus Birmingham, and India. The consistent message: vague, uncontrolled discretion in licensing public assemblies is unconstitutional. The judges were careful. They didn't say police have no role. Other parts of the act allowing directions on routes, timing, or traffic management remain valid. Citizens could still be asked to notify authorities for practical coordination. But the core requirement of permission, the power to say no, you may not assemble, was struck down as null and void. On the discrimination point regarding exemptions for officials, the court also sided with the appellants. Those exemptions didn't fit the Constitution. One judge dissented, believing the provision was necessary for order, but the majority carried the day. Why this case still matters. Mulundika is more than a technical constitutional victory. It marked a real shift in how Zambians exercise their democratic rights. It told the authorities, you can regulate for safety, but you cannot silence or pre-approve the voice of the people. The ruling influenced later amendments to the Public Order Act, moving toward a notification system rather than a permission system. It remains a cornerstone precedent for anyone organizing meetings, protests, or public discussions in Zambia. In the words of the court's philosophy, freedoms of assembly and expression are the lifeblood of democracy. They must be protected not just in theory but in practice.